Blog Talk Radio.
Wallach on Law examines criminal cases and criminal justice and asks the question, we are tough on crime, but is that helping? Can we be smarter and make us safer?
You want answers! I want the truth! You can't handle the truth!
Ian Wallach is a criminal defense attorney and civil rights lawyer in Los Angeles and New York. His cases have ranged from defense of the accused to the prosecution of governments in their treatment of convicts. He's a former Los Angeles deputy public defender and a frequent contributor on legal issues to radio and television shows nationwide.
You're out of order! You're out of order! The whole trial is out of order!
We don't need a bigger vote. This country, our courts are the great levelers. In our courts, all men are created equal.
This is Wallach on Law. Here's your host, Ian Wallach.
Hello, everybody. Hello, and thank you so much for joining us again for this week's episode of Wallach on Law. And today we're going to be discussing the Supreme Court decision in Riley v. California stopping the practice of warrantless cell phone searches. And for that, we welcome Bronson James. Mr. James is a criminal defense attorney who co-authored the brief submitted in the Riley case on behalf of the National Association of Criminal Defense Lawyers. And continuing our discussion on the horrible conditions of L.A. County Jail, we're going to be interviewing Robert Pickett and Darryl Lewis, two men who were held in that facility for over 32 months prior to being acquitted at trial. But let's begin with the current trial spotlight. 21 Los Angeles County Sheriff's deputies have been indicted in federal court on charges of obstruction of justice and other violations of civil rights, primarily arising at conduct at Men's Central Jail in Los Angeles. One of these trials, which involves 6 deputies, is coming to a close. Arguments have been made, and the jury has the case today. Now, this case involves the treatment of Anthony Brown, and it's an obstruction case. Basically, the FBI was doing a secret investigation into allegations of misconduct or of abuse at Men's Central Jail. Anthony Brown was an informant for the FBI. When Los Angeles County deputies discovered that he was an informant, they changed his name in the jail records, moved him around the facility, and purposefully hid him from the FBI while the FBI was trying to extract him. According to the LA Times, these deputies allegedly moved Mr. Brown around in the jails, including the infectious disease wing, keeping him hidden under false names when both his FBI handlers and the U.S. Marshal Service, with a grand jury writ, were looking for him. 2 other deputies are accused of telling witnesses not to cooperate with the FBI and threatening to arrest an FBI agent, falsely telling her there was an impending warrant. Now, the deputies are not surprisingly disputing the allegations. Instead, they're arguing that they were simply worker bees following orders from the sheriff and other top officials. Now, this Nuremberg defense, this defense of I was simply following orders, it's not recognized in the law. U.S. Attorney Brandon Fox reminded the jury of this, and speaking of the higher-ups, he stated, to the extent they're ever charged, that's for another jury, another day. But this Nuremberg defense, this I was just a worker bee defense, it might help sway a juror who doesn't want to hold a law enforcement officer accountable for misconduct. But at a minimum, we need to hold those who arrest others to the same standards as those they arrest. But let's talk about Riley v. California. Yesterday, a unanimous Supreme Court held that a warrantless search of data on a cell phone violated the Fourth Amendment. And to discuss that case, we welcome Bronson James. And Mr. James is a fellow criminal defense attorney. He practices in Portland, Oregon, primarily in appellate law at the state and federal levels. And he's uniquely suited to help us understand this. Prior to becoming a lawyer, Mr. James was a data and technology privacy engineer, and he presently consults on data security and privacy issues. And he's the co-author on the brief that was submitted in the Riley case by the NACDL. Mr. James, welcome to the show.
Yeah, thank you so much for having me.
So thanks. So really quick, bullet summary, what's the central holding in the Riley case? It seems to be pretty clear.
The holding is pretty sweeping. Basically, the practice that had previously existed of searching cell phones of arrestees incident to arrest is no longer permissible. So
okay, right?
The court was very – I'm sorry, go ahead.
No, please, you talk. You were directly involved.
The court was very clear in the ruling. They said when law enforcement wants to search these cell phones, they need to get a warrant. Okay,
perfect. Now, your background in technology, can you explain the argument that you made about how advancements in technology increase privacy expectations?
Well, a critical component of how we presented this case was that the court needed to understand 2 parallel aspects of mobile computing. First was the capacity of these devices to hold an unimaginable amount of data locally and an infinite amount of data with respect to the connections they make to off-site storage and cloud computing. The capacity argument ran parallel, though, to an equally important argument, which was really based on sociology, namely that mobile computing devices are very unique in human history in the way that we have integrated them into our private day-to-day existence. We gave the court a number of statistics that the court repeated in the opinion about the percentage of people that sleep within arm's reaches of their phone. There are people who even shower with the phone.
I read that. It was hysterical. Yeah. And the court did. They ate it up.
Yeah, they did. But what we really wanted to make clear to the court is that we now live in a society where people have physical lives and they have digital virtual lives. And those digital virtual lives contain very private, very personal information. They contain the emails of one's romantic correspondence. They contain your financial information, your health information, your work records. And that virtual life is legitimate and it is deserving of protection. And I'm very, very pleased to see that 9 members of court who are themselves maybe generationally removed from this internet culture nevertheless found that virtual life legitimate and worthy of protection.
Yeah, and not only and right is something that we carry on our person. Access to that is in the phone. That seems to be the object that everybody has literally in their pocket.
It has become the tool that people use to access that aspect of their life. And
now the USA.
Go ahead.
Oh, sorry. Well, I did want to ask, the USA and the state of California, they continually argued that, and I think this is what you're speaking to, that the search of a cell phone was no different than the search of a purse or the search of a wallet. That was not well received by the court. Why is that? And is this why that's wrong? Because the volume of information that can be carried on your phone is just so enormous, or do you think it's more like, why do you think that is?
Well, the state, the Obama administration and the state of California argued with analogy to cases that were really coming out of the 50s and 60s. And so they were arguing about cases that had been considering a person's backpack or their notebook or a crumpled cigarette packet that was in their pocket. And I think that what the court recognized is that mobile computing changes the game, and these old analogies no longer fit how we live our day-to-day lives.
Sure.
And analogizing a cell phone, in Mr. Riley's case it was an iPhone, analogizing all of the data that can be contained on an iPhone and all of the intimate personal details of one's life to a crumpled cigarette pack, the court found ridiculous and very
simply inappropriate.
That.
I found this not only was the decision unanimous, but they seemed to take some efforts to be funny as well, which was
they did,
which was unusual. Stating that there was a quote about how someone from Mars would think that a cell phone was part of the human anatomy, or that what was the other one? Oh, arguing that that saying that a search of a billfold is materially indistinguishable from a search of a phone is like saying a ride on a horse is like a flight to the moon. Both are ways to get from point A to B, but should not otherwise be lumped together in the same sentence. Is that common in your experience in doing appellate law? Is it common for the court to try to be this humorous? If that's because, and why do you think that might have happened here?
I do see it from time to time. It's not really common. I don't think it's terribly common from this court. I'm trying to think of another Roberts Court opinion that I thought achieved that tone, and honestly, none is coming to mind.
Some of the. Oh, sorry. Well, I did want to ask. Yeah, that some of the arguments that when I read the brief, that the court was very cruel, and I think correctly so, to some of the arguments that were put forward by the Obama administration and the state of California. They seem to be not really on solid, intellectually honest ground. And I'd like to ask you about two of them. The first was this argument that we need to access a phone because someone might have, the Confederates are coming, that someone might have texted. What was this argument, and how did the court respond?
So this is an argument that they raised that has been successful as this issue percolated up through the states and through various circuits. This was the notion, I've always referred to it because somebody used it in an argument with me this way, as the fry the chip argument. We're afraid that somebody, some Confederate, et cetera, is going to remotely wipe the data. And so, when that was in the brief, we asked the court to specifically ask the government, please ask the government to give you one example anywhere in the country where this has actually occurred. And the court took us up on that. And in oral argument, they put that question to the Solicitor General of California not once but 3 times before it was answered. And eventually the government admitted they had no actual example of this ever occurring.
Unbelievable. Now, the other concern was remote wiping. They were saying, well, we need to look at the phones because otherwise there's ways to get rid of the phone by sending a signal or a program where it wipes itself if it leaves a geographical area. You stated this argument rings hollow. Why did it ring hollow?
Well, for one thing, the government has a number of ways to protect against any sort of wiping. All of the parties involved suggested that the government could employ what's called a Faraday bag. And a Faraday bag is basically, it's essentially a foil baggie that prevents electromagnetic waves. And the fact is that there's a large number of law enforcement agencies that already employ Faraday bags. So to say that wasn't an option to them was simply not true. The other is that a number of law enforcement agencies, I live up in Portland, Oregon, and we have a number of police cars that have this device in the car itself. And it's a device that will extract in a matter of minutes the entire data all the data from a cell phone and makes a copy of it there for law enforcement. So the notion that this data is extraordinarily perishable simply is not accurate.
Right. I also love the way that you closed that argument because you said they could always, if they want to, separate it from the network, if they're afraid of some signal coming in that's going to cause it to blast and erase its data, they could do something as brilliant as powering it off.
Yes. There is always the low-tech, low financial impact solution of simply turning the device off.
Unbelievable. Now, you made a very strong argument, and I wasn't familiar with the briefings in the lower case, but before this court, but I had read certainly the Diaz case and other cases. You made a very strong First Amendment argument that I hadn't considered before, talking about how phones laws that govern the way we attack phones should be looked at a higher level of scrutiny because they're, well, I don't want to say argument, but perhaps you could expound a little bit. Is there instruments of the First Amendment? Yeah.
Yeah, my position was that the phone has become our quintessential First Amendment tool in the digital age. And I think the great example of this is the Chicago Tribune, who last year, or might be 2 years ago now, basically fired all of their staff photographers and issued all the reporters iPhones to take photographs in the field. And in an era where people are blogging, tweeting, and more people are getting their news sources from essentially community-driven live news streams, the cell phone has become our First Amendment expression. It is just as much a reporter's notepad as the notepad in the trench coat from the reporters in the 50s. And the law is clear that First Amendment instruments deserve heightened scrutiny.
I had not considered that. It was a fascinating read. Some people that I had spoken to had predicted the outcome in the Riley case, and their argument was, and I'd like to get your take on it, that judges use phones. And you had stated that they're a little remote from this generation, but they do drive cars. They didn't like the idea of a GPS system being tracked on a car, without a warrant, and they thought that maybe this is because it was something personal in the higher echelons of society that it was going to rule, that a warrant was required. Do you agree with that? Do you think that's possible?
Well, I can't deny that whenever you have a case that impacts a broad swath of society and that has some touchstone that the court can personally relate to, because even if the judges don't use phones themselves, they certainly have family members who do.
Sure.
So I can't deny that doesn't help in a case like this. I will say, however, I was surprised at the breadth of the opinion that they did issue, particularly with respect to the Worry case.
In what sense? And we only got about a minute, so I have a couple more things.
Sure.
Please express your in what sense in the worry case?
Well, my fear was that the court was going to try to craft a rule based on technology. And the phone in Worry was a much older phone. It didn't have the same internet abilities as Riley's iPhone. And I was afraid that might create a division for the court. But they didn't take the bait on that, to their credit, and they just announced a sweeping rule which should be easy to apply.
Yeah, fantastic. Well, and this, by the way, I mean, this is a big win. Some people argued, and we'll talk about this another time, if this was a battle between powers of officers and the powers of magistrates, officers saying we should be able to do this, judges saying you're not qualified. But still, it's all that's been preserved here is the capacity to preserve evidence that's available if you get a warrant. It's not like the stuff's never going to be looked at. They can still go to they can still go to a magistrate with the phone, and if they have the right reasons, the magistrate may very well issue a warrant. Is that correct?
That's absolutely correct. I mean, all this does is reassert the historical constitutional principle that we prefer warrants in this country.
Right. That's fantastic. And lastly, what do you see on the horizon? I mean, Alito talked about, I believe that there might be a call for some states to take some action. Do you think this is going to be a finite area law in light of the strong voice that the court had, or do you think that that we might see some fallback as a result of anything?
Oh, this is not the last that we're going to see of cell phones. I would predict for you, much like how we had a 20-year span of the court considering the Fourth Amendment with respect to automobiles, we're going to see the court consider the Fourth and Fifth Amendment with respect to cell phones. There are already cases percolating up on issues such as, can the police compel someone to give up the password to their phone? All right. How should a magistrate craft a warrant with respect to data? How long can the police keep innocent data that isn't in compliance with the warrant? All of these issues are going to eventually need to be resolved, and I think we will start to see them head to the court over the next 5 to 10 years.
Well, Mr. James, thank you. Thank you so much, not only for the work that you did, but also for your time here helping us sort of understand it. It's been wonderful to have you on the show. Thank you very, very much.
Well, thank you for having me.
It's my pleasure. And if you out there, if you're listening, if you're interested in learning more about Mr. James or at his work, you can visit his website at www.bronsonjames.com. And if you're in Portland and you have a problem, you can certainly give him a call and feel comforted that you and your problem are in the best of hands. So thank him so much for being here. All right, now I'd like to talk back to the situation at Men's Central Jail. The ACLU has been calling for the closure of this facility for years. This month, the Department of Justice called its conditions deplorable, stating that they present rather than they prevent a risk of suicides. The Department of Justice actually said that this jail is so bad, people are killing themselves, and they cited a huge rise in suicides at this facility. And 21 sheriff's deputies have been indicted in federal court for allegations including violating an inmate's civil rights in Men's Central. Now, I'm hoping that we have, to better understand this, I mean, I can talk about it in theory and what the ACLU said, but let's talk to two individuals who are actually there. And for that, I'd like to welcome Robert Pickens and Darryl Lewis, who were held for over 32 months prior to being acquitted at trial. Darryl, Robert, are you here?
Yes, Darryl.
Thank you guys so much. So we have about 10 minutes, and first let's just talk about, and I know that what happened to you and what brought you into the judicial system is a story in and of itself, and we're not going to have time today to talk about that in great detail. But on May 24th, 2011, where were you guys? What were you doing?
I was dropping Mr. Pickett off, leaving from my place of residence, taking him to his place of residence, and as we're leaving from his house, that's when we started getting shot from that point on.
Okay, and how many times you were shot by LA County? You were shot by the police, right?
Yes.
And how many times were you shot?
I was shot 6 times, and Mr. Pickett was shot 9.
Okay, and I believe those were 3 times to the head, right?
It was once to the head, and the rest was all upper shots to the body.
Okay. When did you first learn what you had been accused of doing? Darryl, Mr. Lewis?
Go.
Oh, we're having a little bit of a problem. I think you're going to have to, if you're on speakerphone, you're going to have to pick up the phone. Sorry about that. We'll just do an interview quickly with Darryl, and then we'll flip over to Robert if you're together.
Okay.
Okay. So, how far? Let's jump straight to you coming into Men's Central Jail. Describe the jail while you were there. Describe what it looks like.
It's terrible. The trial module, it's infested with roaches, mice. It's mold in the showers. It's mandatory that you wear shoes so you won't get no fungus on your feet. The medical is very bad.
Wait. I want to go back to the shoes. So they give you shoes. So there's a problem with mold on the floor, and they order you to wear shoes in the shower so the mold doesn't hurt your feet?
No, you have to buy the shower shoes from them.
They order you to buy them. How many men were in your cells?
It's overcrowded. It was 10 in the cell, but the cell is only designed for 6 men.
Unbelievable. And then what do you do? Is there fresh air? Can you talk about?
No, it's reconditioned air. It's circulated air that they pump in. It's no fresh air.
The Department of Justice has called it, vermin infested.
I agree.
You agree?
Yes.
Can you talk about that? I mean, that's how it sounds.
When they say vermin infested, it's rats, mice, roaches. I even had an incident that where it was a bat up under my bed. That was at Wayside. Another guy found a tarantula up under his bed. So it's kind of dangerous too.
Unbelievable. Now, does the overcrowding contribute to a sense of potential violence, or did you feel scared of physical threats?
Yeah, every day, because everything is so segregated in there. You got to watch what tables you use, what phones you're on, what toilets and sinks to use, because every race has different phones, toilets, and sinks and tables that they're assigned to that race. So whenever somebody goes outside of these rules, whatever race it may be, it can be a possible problem between the two races or whatever, on whose table that they ain't supposed to be on.
Amazing. Now, the courts, both the federal government and several civil actions have set their sights on the sheriff's department, claiming that allegations of abuse or lack of inmate care such that it violated the inmate's civil rights. How do you think the sheriffs took care of the inmate population?
Poorly, because the way you do it, if you do have a problem, just say, for example, a common cold, you would have to put in an inmate request form and give it to one of the trustees outside so they can put it in a box, and you just got to wait on them to call you whenever that may be. And sometimes you may have to do that 3 and 4 times, or just go man down, what they call, where you just tell them, he's hurt real bad, and then they'll try to bring somebody in.
Incredible. Now, is Mr. First of all, let's be glad that you're out. Let's be glad that you're out, and this is behind you. I'm going to ask you a question. I'm going to ask, what advice would you give to someone who's inside, or to the family of someone inside, to relate to them? What kind of advice would you give?
I'll tell them, just don't give up, especially if you know that you're right and you didn't do this crime. They always offer you a deal and hope that you would take a deal just to go and send you up and out the way, to try to, I guess, cut court costs or whatever, however they do it. But I just tell them, just stay strong and keep their head up and don't give up.
Now, how easy, you spent 32 months waiting for something, for a trial, and the right result came out, and you were acquitted and reasonably quickly. What was it like trying to assimilate back into, your pre-incarceration life?
As far as back into society?
Yeah.
It's kind of hard, because now that I have this injury from the shooting, I can't go back to work, so I'm going through a few different changes, It's me, myself, I just try to find God in my life and bring some balance that way, just so I can keep my mind off of what's really actually going on.
When you were released, were there any programs made available to help you find a job, or any therapy programs to deal with, the fact that you had been there for so long, or was any of that available to you?
Through the grace of God, through my attorneys, yes, that was possible. But as far as the therapy through the jail system or anything, no, I never got any of that in there.
Unbelievable. Well, the good news is that you're out, and also the good news is that you're willing to come on and share some of your experiences, and I'm hoping that people will talk about it, and hopefully in the future people won't be subjected to the same kind of wrong mistreatment.
Yes, sir.
Darryl, Mr. Lewis, thank you so much for coming on the show. Thank you very much
appreciate it for you putting me on the show.
Thank you for opening our eyes. Thanks so much.
Right. Here's Mr. Pickett.
Hello. Hi, Mr. Pickett. Yeah, hi. I'm doing very well. We are beginning to run a little bit low on show time, so I only have about a minute. So I want to ask you the same question that I asked Mr. Lewis, and that's, you got somebody, they're inside, and you have a chance now to send them a message. What would that message be?
Just to basically stay strong.
Stay strong. And that they came outside. When you came outside, was it easy for you to reconnect with your family, and how is that now?
The reconnection with family was great. After not seeing them for 3 years, being back home was heartfelt. I mean, you got to see the people that you were away from, that you were used to being around for all this time. It's real emotional.
Sure. I want to have you back on the show because I want to hear about your experience and the way that you're coming back. Unfortunately, we are out of time now, so I'm going to have to end this. But thank you so much for coming on today and for helping people understand a little bit about what happened, especially the people who are accused of crimes, let alone who and subjected to this, not even convicted. Thank you for being on the show.
Well, thank you for having me.
Okay, we're gonna close out the show today. I apologize for choking up a bit. It's a little bit hard to hear, and the situation is definitely unjust and definitely in need of change. Today I want to give a quick shout-out. It's the goodbye to Stu Glothen. He was a fantastic leader at the Office of the Public Defender, an incredible trial attorney, a wonderful manager, a steadfast advocate for the less fortunate. He retires today. He protected thousands of people, so thank him. He's absolutely amazing. A special thanks to our guests, Darryl Lewis, Robert Pickett, and Bronson James. And listen, I'd love to hear your thoughts. So if you want to send me your thoughts and your comments, please do so. Send it to me at change@renovatejustice.com. You can also follow my blog at renovatejustice.com or my trial blog at trialfiend.com. Big thanks out to the producers in New York, Mark Goldman and Ryan McCormick. And if you want to reach me, I'm Ian Wallach, wallachlegal.com, and here I am. I'll see you next week. Thank you so much for listening in. And folks, please remember, until next time, let's keep using our heads. Let's stop using our hate. And thank you so much for being here. We're going to sign off right now, and I'll see you next week. Thanks for being here. Thanks a bunch.